what the plaintiff's lawyer is hoping to do at the deposition is to use the power of the video camera and just the intimidation factor of having the deposition taken to, at that point, scare the witness, the target, into settling. And typically the first question out of the plaintiff's lawyer's mouth after, you know, name, rank, serial number, where do you live? First question is, what's your interest in porn? What's your preference in porn? Objection, of course. But the whole idea, again, is more intimidation. And also along those lines, you'll see in Exhibit 4, let's see, Exhibit 4 is a, how many page? I don't know, it's about a 8 or 9 page letter of request for informal discovery to opposing counsel. Again, your target has not been named, your target has not been served with anything, but receives either you on his or her behalf, if you've identified yourself as the target's lawyer, or the target himself or herself, if the target doesn't have a lawyer, gets a 9-page, very official-looking letter requesting informal discovery and everything under the sun. Again, the type of thing that will be rather frightening to a civilian target. Now, is there anything wrong with all of this, or is this just good proactive lawyering? Depends on who you talk to. If you look at the letter, Exhibit 4, from this law firm, Prenda Law, you see under their name at the top of page 1, their slogan, protecting intellectual property. And if you go to their website, they tout themselves as basically leading the charge, the anti-piracy charge. And so they cast themselves in the role of the good guys protecting the United States Constitution and the Copyright Act. There are some other people on the other side of the equation who have different names for them. And it really depends, of course, on which side of the fence that you sit on. I will say this, that my client in one of these cases, who again had never been named and never been served, was listed on this law firm's website under the category, they have a page on their website, not their homepage, but one of their other pages. They have a page called Top Internet Pirates, Top 25 Internet Pirates, I think. And my client was listed by name without having ever been named or served. However, since we're in California, I don't think that I would have been able to successfully file a defamation action because we have the anti-SLAPP laws in California, which are very, 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 very slanted in favor of the speaker of the allegedly defamatory work, and the consequences for the plaintiff in the defamation action, if the plaintiff loses on the anti-SLAPP motion, as some of you may know, are very dire. I mean, if you lose an anti-SLAPP motion, if you're the plaintiff in a defamation action and the defendant brings an anti-SLAPP motion and you lose, the court must award attorney's fees to the defendant. So we're still within the statute of limitations, but so far we have held off on filing the defamation action because we're trying to decide whether or not, or what our chances are of withstanding an anti-SLAPP motion. So this is going on all over the country. I mean, I could see an argument. I mean, some of you may remember last year, I think Ira Opera came in from Opera Sports. Ira and Opera Sports, they have the Surf Network, the Moto Network, and the Snow Network. They are distributing hundreds of titles of films about surfing, motocross, snowboarding, all on the internet. If Ira, if this particular company is being pirated, would it be in their best interests? Would it be legit to pursue people who are illegally uploading and downloading their films without permission using this business model? Maybe, maybe not. Really, again, I'm trying, as a lawyer, to look at both sides of the fence. Now, I think that in this particular case, or in these particular cases, where the plaintiffs are adult XXX rated production companies, the potential for harm is much greater because of the fear factor and the intimidation factor. In fact, one of the plaintiff's lawyers, in fact, for this firm, Prenda, has gone on record as saying that he is really specializing in representing adult entertainment companies that produce gay adult entertainment, because he knows that he can get better, quicker settlements out of the targets who are accused of downloading gay or transsexual porn than straight porn because of the fear factor. It doesn't take too long to realize how scared these people get. And what's surprising to me is how few judges around the country have caught on to this and are doing much about it. There are some judges up in the Northern District of California have caught on to this and have started to deny the motions for expedited discovery to be served on the ISPs. They're starting to deny the motions to take the depositions, but not all. Just some judges in some courts are catching on. There aren't that many cases in San Diego that I'm aware of. There are some, but not as many as in other courts. And I don't really know, I don't have a real good handle on what the judges are doing down here yet. I've had a couple of people contact me about cases down here, but it was one of those dicey situations where they really didn't feel like they wanted to get into retaining legal counsel to fight one of these things very hard, and they were maybe going to go back and plead with the plaintiff's lawyer and try to settle this thing for $1,000 and just get out of it. So I haven't really had a chance yet to dig into what the courts are doing down here. I know one magistrate granted the order allowing expedited discovery to be served on the internet service provider, but with a few protections built in, which things like the internet service provider had to immediately provide notice to the account holder, and the account holder would have either 21 or 30 days to file a motion to quash or some other dispositive motion. And as far as I know, none of these cases have gotten to trial yet. And in one case, in fact brought by this same law firm, Prenda Law, they were required by a judge in the Northern District to identify how many cases they had filed around the country on behalf of all of their clients, because the judge wanted to get a handle on the scope of this. And they filed a responsive pleading with the court, and they identified, you have to forgive me, but in rough numbers, I think there were, this law firm on behalf of several different production companies around the country had filed between 100 and 150 lawsuits around the country, which named between 10 and 15,000 does in total, and had not named one individual defendant by name in any of those cases. The last thing they want to do is name an individual defendant and serve them. Why? A couple of reasons. One, if they name and serve the individual defendant now has the right to serve discovery upon them. They do not want to have to give up, the plaintiffs do not want to have to give up any discovery about their business model, how much money they're making, what their proprietary technology is, how good or bad their data is, what they know is the error rate or anything like that. They also know that in federal court, as some of you litigators may know, once the defendant answers and cross-complains, the plaintiff cannot dismiss its case without permission of the court. And in many of these cases where things get a little hairy and some of the judges start fighting back and issuing orders, denying motions for expedited discovery, what the plaintiff will do is dismiss the case without prejudice, then refile and hope to get a different judge. Well, there's more I could say about all of this, but that's kind of the business model in a nutshell. It involves, obviously, copyrights at their core. It involves litigation in federal court, which I think any of us who litigate or think about litigating or have clients who are interested in litigating or have been forced to litigate are interested in. It's making unbelievable use of court resources. Imagine if, instead of paying one court filing fee for $350 and being able to name 25, 50, or 500 does, they had to pay $350 for each doe. The business model goes out the window. It's all over. In fact, there are very few of these cases in Los Angeles federal court because Los Angeles federal court has a local rule. No more than 10 does may be named without permission of the court. If that rule, if that one simple local rule was imposed by all federal courts around the country, this business model would go away. Now, some may say that's a good thing, some may say it's a bad thing. Again, I haven't yet had a client who's asked me to employ this business model on their behalf. If they would, I don't know how far I would go. But I'd have to think about it because it is very, very clever. I would like to try to be sort of neutral about this and say, well, this is just, this is a close call between good proactive lawyering and extortion, but as you probably gathered, I don't really think it's that close of a call. But there's more I could say about all this, but I'm sure everybody wants to get to the W. So I'll stop now, and any questions, let me know. Be happy to talk about this offline or whatever, and if you didn't get the outline, I'll be happy to send it to you.
A lot of questions. I don't want to ask too many, but I went over to UCSD 3 times to talk to students who were caught up in the IRAA file sharing suits. I took somebody with me. I took Jason Lorenzo. I don't know if you remember him with me.
Sure.
Because I wasn't going to represent these people, and he ended up representing a bunch of them. Every one of them settled, by the way. Yeah. And he was able to work a little bit with the figure that they had. I think it was in the 3,000 range, but there wasn't a lot of wiggle room there for it because, quite honestly, none of these people had any defenses. And
right.
What are you going to do? And in these cases, my guess is the same. You really don't have.
I disagree.
Oh, well,
with all due respect.
Maybe you're right. I'd like to hear your defenses. $800,000 based on the figure you gave of suing $25,000. If everybody paid the $3,400, that'd be almost $1 million. Yeah. So it's a good business model.
It's a great business model.
You can see that.
Yeah.
But the question I had for you was, in terms of, I'd like to hear what you think in terms of counterclaims or defenses to this, because in the kids who were swept up in UCSD, they did it, they downloaded the music, they shared it across the internet, and there wasn't really much that you could say. I know that you're a copyright misuse guy, so maybe that's one of your theories.
That one of my affirmative defenses is copyright misuse, because particularly in that one case that I cited to you, where the plaintiff lawyer refused to provide me with the copyright application or the copyright registration certificate, where there's smoke, there's fire. But that is the exception rather than the rule. In most of these cases, the plaintiff's lawyer will either attach a copy of the copyright application or the registration certificate, or at least make reference to the registration number. But I think copyright misuse's defense, in and of itself, by grabbing all of these people together in one lawsuit and by not giving them an opportunity to defend themselves, but using the power of the federal court to extract these settlements. I think that amounts to copyright misuse. I also think that just because I am allegedly the account holder of the account that you have identified through your proprietary technology, that doesn't mean that I or anyone under my authority or auspices downloaded the film in question on the date in question. It could have been a neighbor. There could, and some judges have started to say in some of the courts, an account holder doesn't, an IP address may equal an account holder, but it does not necessarily equal a defendant. You're going to have to prove that there's a causal relationship between the IP address, which by the way changed sometimes over time, and the target, especially if the target had an unsecured router. Now, in my case, where my client had his deposition taken, and the case settled a week later, my client at the time lived in an apartment building in Menlo Park with 60 other units in it, and he had an unsecured wireless router. How was the plaintiff going to be able to prove that it was him who actually downloaded Punk Rock Orgy in the Woods on March 28, 2011? I don't think they can prove it. Also, there is a theory being developed by some of the defense attorneys that I'm in contact with, that in order to identify all the people in the swarm, the copyright holder, the production company, has to seed the BitTorrent swarm and make some or all of the film available in order to entice the alleged bad guys to then participate in distributing the film. That gives rise to defenses as well.
Has anybody looked into whether their proprietary technology could in fact be circumvention under the Digital Millennium Copyright Act?
Nobody has really been able to look into much of this because nobody is a defendant that has the right to do discovery of the plaintiff. This is almost an Orwellian use of the federal court system. Remember what the guy said to me, what the plaintiff's lawyer said to me. We don't provide free discovery to unnamed parties. And yet, look at the 9-page letter that they sent my client asking for discovery from him. It's bizarre. Think about it. You're an unnamed party. All you are, allegedly, is a witness. What rights do you have in court to defend yourself, other than to file a motion to quash? And now you're an unnamed, but you're still an unnamed party. You don't have the right to generate any discovery unless you want to file a debt relief action. By the way, there is a law firm in San Francisco that has taken a novel approach to this. This opens another whole can of worms, but I'll mention it since we're all interested in this stuff. What they have done on behalf of a couple of targets is they have filed a debt relief action in federal court to declare the copyright in question unenforceable on the grounds that pornography does not fit the test for science and useful arts as set forth in Article 1, Section 8 of the Constitution, which is the basis for the Copyright Act. And they've cited some California law for the proposition that pornography is not entitled to copyright protection, despite some cases in California which say that it is. They've got an interesting theory that none of those decisions have been granted by the California Supreme Court. They were a non-en banc decision of the court, and therefore are not necessarily binding on all courts in California. Needless to say, when they file the debt relief action, the porn production company calls them up and says, "What's it going to take to settle?" Well, let's do a walkaway. Well, in at least one of the cases, the law firm that's defending the target and has filed the debt relief action has said, "No walkaway. We're not walking away. You're paying our attorney's fees." No, we won't. Yes, we will. Yes, you will. No, we won't. They're going to litigate that. We'll see how far that goes. So that's, an attempt to turn the tables.
Civil conspiracy claim preempted?
Preempted. Some judges are starting to say civil conspiracy and the negligence claims are preempted by the Copyright Act. Not all judges, but some of them. Yes, sir.
Well, has there been any movement on the more mainstream producers with the Hurt Locker and the Expendables?
I just haven't heard a lot about.
Because it isn't that, I don't know the circumstances of the case you two guys are talking about, UCSD, but it seems to me, if I'm the producer of the Hurt Locker, I don't want if you take this whole discussion out of the realm of porn.
That's right.
It all sounds pretty legitimate to me.
Yeah.
And why aren't the studios involved in this? Why haven't they jumped on this bandwagon?
I don't know the answer to that. I'm speculating that it's because they don't want to suffer the bad PR that the RIAA and the record labels suffered.
Mm-hmm.
But it's a great question, because it seems to me like a great business model for the studios. But maybe they've also figured out that they don't want to be in the position of having to seed the BitTorrent swarm and get accused of...
hauling off a 14-year-old who downloaded the Avenger.
Right.
Is there any record of this content actually being licensed or sold legitimately, or is this being created specifically to induce people?
We don't know. I don't know the answer to that question. I think it's a great question. There is a lot of speculation that this content is not otherwise available, but I don't have any hard data, you'll excuse the phrase, to be able to answer the question one way or the other.
When you say seeded, does that mean somebody has to proactively download, say, a DVD copy of something to get the swarm started?
What the theory is that the plaintiffs are uploading their content onto one of the BitTorrent protocols, making it available anonymously, knowing that this is going to happen, and looking to find out who jumps in and gets into the swarm, and then name them as those in the complaint. Now, again, I haven't seen any proof of that, but there's a group of about 20 or 30 lawyers around the country, like myself, who are defending one or more of these claims and advising people. I'm sorry?
They're called Jedis.
Jedis?
Jedis.
Yeah. And we have a Yahoo user group where we freely exchange information and tips and ideas and news about what's going on in their jurisdiction versus our jurisdiction. If any of you are interested, I'd be happy to invite you or show you how to get into the user group. You have to certify that you don't represent plaintiffs who are using this business model to pursue copyright infringement claims, and other than that, anybody's free to join. Val.
So you mentioned that the model was originally, that it was modeled on what was going on in Britain.
Yes.
Right? Do we, since that's had a little longer to play out, do we know where any of that has gone?
I don't know where the British courts are and where the British law firm is that was really pursuing this. But that's a really good question. I'd like to know. Do you know?
Yeah, well, one of my friends was actually targeted by the British law firm, and it was in the news all over that they, whatever public watchdog group, whatever that deals with lawyers over there.
Their version of EFF?
Yeah, so whatever, or the Bar Association or whatever, basically ended up disbanding the law firm for violating whatever ethical rules that they shouldn't have been doing that sort of thing.
You said disbanding the law firm?
Yeah, like they got shut down basically.
Right.
And they were told that they couldn't keep doing that. And so I think they were also told to refund all the money that they got from people who settled early, because it was just, there were too many people complaining to whatever local government groups saying that this is not something they should be doing. And so they were shut down or something like that.
And along those lines, I believe it was last month, a law firm in, I believe, Kentucky filed a class action lawsuit on behalf of of a target against several of the adult entertainment production companies on behalf of all similarly situated targets, both currently targeted and those who've paid. And we're going to be watching with great interest where that class action lawsuit goes. And I'm talking to one of my clients here in California about whether or not he wants to be the class action plaintiff in a lawsuit here in California. What's an oddball aberration in one of the cases that I handled is the law firm that was pursuing my client is an Illinois law corporation with an office in Northern California, but they have not qualified to do business in California, nor have they registered with the State Bar of California. So I'm waiting to meet with my client to talk about whether my client is interested in filing a complaint with the State Bar, because I think that goes too far. I mean, if you're going to do business in California, you're supposed to qualify to do business in California.
Well, my other issue with the whole case is, to me, seems like, they really have no way of knowing what state these alleged defendants are in the first place when they're filing. And so, they might file in California, but some of the defendants,
yes,
the does that they're naming may not actually be in California, and so they might even have any jurisdiction over them.
Oh, no, there are tremendous jurisdictional issues, and that's why there have been quite a few motions to sever that have been filed on the grounds that either we don't all belong together, or you've named defendants who don't even live in the state of California if the lawsuit's filed in California, or you've named defendants who don't even live in Minnesota if the lawsuit's been filed in Minnesota. And as I said, we're seeing inconsistent results from the courts. I have been looking for an opportunity to get in front of a group of federal judges, because I'm sure they meet once or twice a year. I'd like to be able to present to the group of federal judges to see if there's any way of getting them to talk amongst themselves about developing a common way of dealing with these questions, but so far I haven't been able to. They're a little hard nut to crack. All righty then. Thanks for listening. I hope that was informative.